Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5088, Murray Braun, appellant versus United States of America et al. Mr. Tolchin for the appellant, Mr. Goldman, amici curiae, Mr. Koppel for the appellates.
All right, Mr. Colchin, good morning. You may proceed.
Good morning, Your Honor. I just want to make sure I'm not having a technical problem. I don't see you, but I don't know if that's intentional.
You don't. Go ahead.
Okay. Your Honor, Mr. Goldman and I have, in a general way, divided the topics we're going to address, and I'm going to jump right to the later topics. So the government puts a huge emphasis on the word available, the words, the funds available to distribute. And they read into the word available a whole lot of discretion that they say the special master has to decide what's available. And I think that may be the core of this issue here. The word funds available, as used in the statute, does not mean that the special master has discretion to simply decide not to make a distribution. The mandate of the statute is that there should be an annual distribution whenever there are funds available. There is a trigger amount that if there's $100 million in the fund or more, a special master has to be appointed, and there's a timeline of what the special master is supposed to do. The special master is supposed to get appointed, review any claims that haven't been ruled on as to eligibility, authorize payment, report to Congress on the payment, and finish the appointment within a year. And then there's not supposed to be another special master unless and until there's a sufficient amount.
Mr. Tolcher, I thought your argument was that they had to pay on January 1st.
Well, that's
right.
There's two aspects to my argument, Judge Tatel.
Well, I was going to ask you, but that is one of your arguments, right?
Yes. So,
okay. Well, was it your 20HA letter this morning that submitted this section? I think it's HI of the statute
about the congressional report.
Yeah, I mean this.
Yes.
Maybe I'm misreading it, but this seems to support the government's view because it says that first of all, it very clearly indicates, as the government argues, that there's a difference between the word authorization and payment. That's the number one. But also, you're right, it requires a congressional report within 30 days. But that report is about payments that have been made and not made, which suggests that there is no deadline.
Oh, Your Honor, I can address that. I know exactly what you're thinking, and I think you're misapprehending it.
Go ahead.
The enumerated things that are supposed to be in that report addressing eligible claims that have not been made is because nobody's getting their full claim paid in a given year. There are $10 billion worth of claims that have been submitted to the fund, and the money is divided up pro rata. So what's being reported to Congress is we've had this many claims, we've paid out this many, and we still owe in future years such and such an amount of money. That's the part of the congressional report that refers to claims unpaid. What an earlier section of that congressional report says is that the special master is supposed to report, but within 30 days after making payments, is supposed to report about the payments that were made and then what remains unpaid in the fund. But the point is that the special master is supposed to be appointed for at most a year. There's supposed to be a beginning, a middle, and an end. The beginning is there's $100 million, we've got to appoint a special master. The special master is supposed to make whatever rulings need to be made, whatever claims have been submitted since the last time there was a special master, approve or disallow individual claimants, and authorize payment. That's where we come the real semantic game. The government says authorized payment means just say, okay, you can pay, but doesn't mean actually pay. We contend that for the special master to authorize payment and then report to Congress about the payments means that money is supposed to be paid. And it's supposed to be paid by the deadline set in the statute. Otherwise, it's
So
open-ended.
please tell me what your definition of authorize is, because I've seen sort of different ones through your brief, and I'm trying to figure out what you can tell me what you define authorize as under this statute.
Well, authorize or authorized payment. Because you can
Authorized payment.
can
Authorized payment. That's your key phrase here.
Authorized payment means pay. Black and white, it means pay. If it doesn't mean pay, then we've got nothing. There's no mechanism in the statute for the victims to ever get their money.
Elsewhere in your briefing, you had indicated that you thought authorized payment might mean when your client got his letter saying, here's how much money you're going to come in the future payments.
No, that's the government's argument, and I argue for.
No. I'm not talking about eligibility. That's their argument. I'm talking about the second letter that he received that said, going to make a distribution. Here's how many dollars you're going to get.
We do not contend that.
You disavow that argument now.
Well, we do not contend that that satisfies the requirement of authorizing payment because there's no payment involved. That's telling somebody how much they might one day expect to get if payment is ever made. But you know what? There's a theoretical way, if they never make payment, so there will never be a payment. And at the end
that's what mandamus is for. I mean, there's ways for the courts to deal with that. Can I finish my question, please? There are lots of statutes that don't have deadlines that courts will read into a statute. The question that Judge Millett is asking you is the government says that the word authorized and the word payment mean different things. And that seems to be right. The way the government works is an agency authorizes a payment, it authorizes it, and then the Treasury or another agency actually pays it. They're two different acts. And that's what this language seems to say.
Here you have the fund is, by statute, the fund is in the Treasury. It's not another agency. It's a ledger sheet in the Treasury. And the special master is the one who's supposed to authorize the payment. And if we leave it at that, Your Honor brought up the word mandamus, but if we ever did a mandamus, they'll say what they're saying now, which is that the special master has discretion. And you know what? It's ludicrous.
If the statute said what you said, it would just say simply the special master must pay by January 1. That's what it would say.
Oh, the special master doesn't.
Also, let me ask you this. The government makes an argument in their brief that if the deadline would, what you suggest, that the whole thing would be pretty much unworkable. And you didn't respond to that. They said the system with all the steps that have to be taken in the pro-rata and all that it just couldn't happen by January 1. What's your answer to that?
My answer is that is a parade of horribles argument that the government conjured up, and it's just not true.
Well, it's not a parade of horribles. They're saying it would be impossible for them to do this. That's what they're saying.
All claims have to be submitted within 90 days of when you get your judgment.
Right.
There is a time period for the special master to rule on them. If a claimant doesn't like the ruling, there is a procedure for an appeal, which is just an appeal to the special master. And if that's completed before the distribution, fine. If it's not completed before the distribution, so the distribution can go on without that claimant, and that claimant will be part of the following year's distribution. There's nothing that says that a person who's been denied and has a pending appeal, that everyone has to wait for them. All the other stuff that they talk about, they need to hire an economist to calculate the pro-rata distribution. It's nonsense. They use a spreadsheet. They put in everybody's claim amount, and the spreadsheet calculates what pro-rata is. They have 5 Justice Department staffers assigned to them. They have a special master, and there's no reason that they can't complete the very mundane procedure of figuring out how much money we have and multiplying it by some percentages and mailing out checks. And in fact, they've done it in past years. So,
Judge Tatel, have you got your answer?
Yes, I'm
Okay.
done.
Can I ask just one more? Can I ask one more question, Judge Henderson?
Sure.
On your complaints, I'm just trying again to pin down this authorized. In paragraph 75, you talk about actually transmitting the money. That's the definition you've articulated here. Enabling the transmission of money, directing anyone to transmit money, or authorizing money to be transmitted. And I want to make sure I'm understanding your position. You're now focusing on that first one, that authorized payment means the actually transmitting the payment.
correct. There's a reason it has to be, Judge Millett.
Okay, I'm just clarifying your language. I had one other question. If there were $1 in excess of the 100 million balance in the fund, would the special master be obligated at that point to do a distribution?
Well, I don't. Your question is a little confusing. If there's $100 million, that's a substantial amount.
I know. I said if there's $1 in excess of that, so 100
Well,
million one.
I don't know.
Excuse me. If there's $100 million and $1,
Mhm.
is a special master obligated to make a distribution at that point?
Of $100 million and $1?
Yes.
$100 million is not a threshold for distribution.
It seems to me it's a yes or no answer. If it's $100 million and $1, under your theory, is the special master obligated to make a distribution at that point?
The special master at that point is obligated to set aside reserves for whatever known quantities need to be reserved for and to distribute the balance. And if there's $100 million and $1, if there's set aside whatever reserves for pending claims or whatever things need to be reserved for, and distribute the rest. The statute says distribute annually. Yeah, I know you're trying to get me to talk about if there's $1 and that has to be distributed, but that I'm having.
I'm trying to get you anything. I'm just trying to ask you a question to understand your position.
But I'm having trouble with your question because you're making it like the fact like $1 more than 100 million is a significant is a significant issue. If there's $100 million and $1. I think you mean to say if the $100 million is spoken for.
That's not what I mean to say at all.
Okay. If there's $100 million and $1, then yes, the special master is obligated to make a distribution. That's why.
Thank you. Mr. Tolchin, you're way over your time. Mr. Goldman. You need to unmute yourself.
Thank you. May it please the court, my name is Jerry Goldman. Thank you for the opportunity to be able to participate in this appeal on behalf of the 9/11 victims. I'm going to be speaking about the issue of the 25%, whether or not and when that 25%, the difference between 50-50 and 75-25, applies in this case. We suggest that the plain language of the statute, the Clarification Act, which was put into effect to protect the 9/11 plaintiffs from dilution, add them into the program, and then make sure there was sufficient funds so they'd have some sort of meaningful compensation, was designed to operate the way the statute in its express terms states. Its express terms, the Clarification Act, which was a technical correction, simply changed in this regard one word: 50 to 75. If Congress wanted a different effective date for that provision, it would have modified that effective date in that provision, as it did with other provisions in the Clarification Act, such as attorney fees.
Well, wait, I'm sorry. Let's just start with the plain language of the Clarification Act. It says this section and the amendments made by this section. Now, one of the amendments made by this section is to increase, to add 25%, right? That's one of the amendments.
Right.
So it says this section and the additional 25% shall take effect on the date of the enactment of this act, November 9th. So, it seems clear that the amendment, the 25% amendment, becomes effective on the date of the enactment of the Clarifications Act.
I beg to differ, Judge Henderson. The statute, it's itself.
I'm judging. That's okay. Go ahead. What?
Oh, Judge Tatel, I'm sorry about that. The statute itself, which is reproduced in the appendix.
Well, I just read you. Just stick with the language that I just read to you.
Correct. But
Tell me, it says that the 25% becomes effective on the date of the Clarification Act.
I respectfully disagree, Your Honor. It doesn't say that it becomes effective on the date of the Clarification Act. What it says is, in that particular portion, that it simply changed the percentage, and then the rest of that sentence
I still don't
act.
understand. It says, just help me with the language. Shall take effect on the date of the enactment of this act.
Correct. The enactment of this act, I suggest, refers to the original act, the VSST Act from 2015. In other changes in the Clarification Act, they refer to the date of the Clarification Act by date, or they refer specifically to the Clarification Act. What I suggest is, when Congress uses specific terms, it's our obligation, justice, the courts, and what have you, to follow those terms of Congress.
Can I just clarify your answer to Judge Tatel? So when you're saying that the word "this act," the "this" THIS, and that Clarification Act didn't refer to the Clarification Act, that in fact referred to the original statute.
In part, yes, and I'll go further than that, Your Honor. The actual terms in the statute doesn't use the word act. It just changes the word by striking 1/2 and inserting 75%. That's what the law passed by Congress said. And then it had to be inserted into the original 2015 Act.
That was the quote amendment that became effective. The change from 50 to 75 was the amendment, quote, the amendment, right? Correct?
Correct.
Okay.
Correct. But the exact words by Congress, unlike, for example, when it changed the formula for attorney fees, unlike, for example, when it allowed spouses, children, and estates to participate, though in all of those, they use the specific reference, as Your Honor talked about, the reference to the Clarification Act. In this particular provision, it didn't do so because it makes sense. They needed an influx of money because of the numbers involved. The 9/11 victims were 80% of this fund.
Well, the government points out that this will increase the amount of money.
It
will increase it by 25%, just not as much as if it was retroactive. So in other words, Congress is accomplishing its purpose. Congress wanted to increase the amount of money available for victims, and it did it. Your argument is that that increase should be retroactive. So it's perfectly consistent with Congress's purpose. Right?
I'm suggesting the word effective rather than retroactive. What happened is victims received.
Can you just please respond to my point?
Sure.
You said that the government's argument is inconsistent with congressional purpose of increasing the amount of money available to victims. And the government's interpretation does do that.
I suggest it does not, because victims receive 4.82% in the prior year and dropped down to less than 1%.
But from the effective date of the Clarification Act onward, there's an additional 25%, right?
From the effective date of the Clarification Act onwards, there will be additional funds if there are future rounds. That is correct.
That's my point. So, yeah.
All right, if there are no more questions.
I'm sorry.
Okay.
If Judge Tatel is done, I had one more. question, and that is, it's pretty established rule of statutory construction for separation of powers reasons that no money is going, courts will not construe a statute to take money out of the treasury unless Congress has been said so specifically. And we know from E5 in the statute, 20144E5, that when Congress wants to appropriate funds from the treasury for this statute, it says so in plain terms. There is appropriated to the fund out of any money in the treasury. That was the initial distribution. That isn't what the language that you're relying on looks like at all. And I understand your argument, right? If someone doesn't pick up the Clarification Act and see that effective date and you just read the statute, I understand your argument. But there is the Clarification Act. There is the language in E2 that says these payments are supposed to start beginning December 18th, 2015, which can't possibly happen with respect to the 75% rather than 50%. They can't go back. Clarification Act says you can't start until 2019, and this statute says you're supposed to start in 2015. It's an impossibility. So given that, isn't there, how can we say that Congress has specifically, in the text you point to or other text you want to point me to now, appropriated funds out of the treasury to make up that difference that you think should be made up now?
I suggest the answer to that is clear. We're not talking about general appropriated funds out of the treasury. We're talking about earmarked funds coming from sanctions, forfeiture, whatever, which was separate and distinct accounts. And
no, but that money went into the treasury, right? The extra 50 initially between December 15th, 2015 and November 2019 of the Clarification Act, 50% went into this fund and 50% went into the treasury. And under your reading of the statute, you say this language tells a court, you want this court to order the special master, the government, to go get that make up 25%, get you to 75% for the span of 4 years to make it up from December 2015 to 2019, make up that, get it out of the general treasury.
I'm suggesting,
go ahead, please.
I'm sorry, Your Honor. I'm suggesting it does not come out of the general treasury. It comes out of this fund, these escrowed funds, these forfeiture funds that it kept in a
They're
separate...
not escrowed. First of all, put aside the forfeiture ones, because it's not all that. It's also penalties.
Correct.
Right? They aren't. Do you have evidence that they've been escrowed since they were first paid?
Well, footnote 2 on page 29 of the government's brief, they indicate that they were escrowed. Second,
they're talking about the forfeiture fund, the ones that have been forfeited. I said not the forfeited ones, the penalties.
correct.
Put aside forfeiture for the moment. There's been no escrow.
The government indicated on footnote 2 that they set those funds aside.
Okay, then that's great. I will ask them to clarify that. Okay.
And then
If that didn't happen, go ahead. You have a second.
And if that didn't happen,
Mhm.
there's always this mass of funds waiting to move out. Some of it moves out to the victims of state sponsors of terrorism fund, which is for the benefit, and Congress's intent was this is for the benefit of victims of terrorism. And the rest of it, be it 50% or 25%, goes into a discretionary account, not subject to congressional action, but not the general funds of the Treasury, but a discretionary account of the Department of Justice. What we're saying is that mass of funds, to follow the congressional intent, the goal of helping victims of terrorism, is to take precedence and use those monies in that account, be it to make up this difference and in the future to go forward.
So you say there's a separate account. It's not the Treasury. It's not this fund. There's another fund where.
That's what it appears based on the language in the briefing and our understanding of it, that whatever is not used for this is a discretionary account of the Department of Justice.
Okay.
They use it to make grants and what have you.
Okay, thank you.
All
Thank
right. Mr. Koppel, good morning.
Morning, Your Honors. May it please the court, I'm Josh Kopp on behalf of the United States. As relevant here, the Victims of State-Sponsored Terrorism Act made two distinct appropriations. First, in subsection E5, Congress appropriated to the VSST fund $1.025 billion out of any money in the Treasury not otherwise appropriated, that is, out of the general fund. Second, in subsection E2A2, Congress appropriated 50% of certain civil penalties or fines forfeited or paid to the United States after December 18th, 2015. The first of these provisions appropriates money already in the Treasury. The second sets up a scheme for determining how incoming receipts should be allocated among various government funds. And because subsection E2 is designed to allocate incoming receipts, the Clarification Act's amendment of the provision in 2019, increasing the percentage of receipts that should be devoted to the VSST fund, necessarily only affects the allocation of civil fines and penalties paid after enactment of the Clarification Act. If Congress had intended in 2019 to allocate additional money already held by the government, it would have done so in the same way it did so in the original VSST Act, using the language of subsection E5. That understanding of the statute is consistent with Congress's identification of the source of ongoing funding for the VSST fund. Subsection E2 states that a percentage of the civil penalties and fines themselves is to be deposited into the VSST fund.
Can you respond to their understanding of your footnote 2 in your brief? They seem to think that, at least amicus, we can't attribute it to Mr. Tolkien, but seem to think there's another fund, or at least forfeiture monies just sit there year after year if unused.
That's not correct. So what we're saying in that footnote is that there were two assets that had recently, prior to the passage of the Clarification Act, recently been forfeited. 50% of the funds were sent to the VSST fund, and the assets forfeiture fund staff at the Department of Justice was in the process of divvying up the other 50%. So sharing it with local partners and other federal agency partners. When this litigation was filed, the DOJ Assets Forfeiture Fund paused that process and held on to those funds in case there was an adverse judgment in this case. But that's just with regard to two particular forfeitures that comprise a very small portion of the total amount of civil fines and penalties paid between 2015 and 2019. All the civil fines and penalties themselves were split between the VSST fund and the general fund. Forfeitures that went into the Treasury Forfeiture Fund, those went into the fund itself. They were spent as permitted and required by statute or rescinded by Congress. And the same with, I believe, some of the forfeitures that went into the Assets Forfeiture Fund as well.
So do I hear you? So what you're saying then is that if the court were to rule that that the 25% increase is retroactive, that money would have to come out of general Treasury funds, right? There's no fund set aside for that.
That's right. There's no money set aside for that. There's a small, very small portion, but minuscule compared to the whole. That's right.
Let me ask you. I have a couple of. I'm sorry, Judge Millett. Did you want to pursue that issue? Go ahead.
No, go ahead. Go ahead.
Oh, I just wanted to ask you a few other clarifying questions, if I could. And would you please just go back to basics and tell us about the government's view about authorized versus payment and how this works? Just explain it to us, would you please?
Sure. So when the statute creates a deadline for authorizing payment, that means that is the deadline for when the special master has to make an initial eligibility determination on all claims that have been submitted by the application deadline for that round of distributions.
Well, let me just interrupt you. The plaintiff says that there's only one eligibility determination made at the beginning and then none after that. Is that accurate?
That's correct.
That is correct. So that means, so under your theory, on January 1st, the special master authorizes amounts. to eligible claims, correct?
That's right.
And then the payment is made later after the pro-rata calculations are done. Is that the way it works?
So after the special master makes the initial eligibility determination, the claimant has 30 days. If their claim has been denied in whole or in part, they have 30 days to seek a hearing.
Well, suppose it's been granted.
So the special master has to still hold hearings for those whose claims have been denied, make a final written decision as to their claims, because only once all claimants, claims have been adjudicated can the pro rata calculation be made.
That's helpful. Okay, so I see. And so just explain mechanically, once an amount is authorized and the claims hearings are completed and the special master makes the pro rata calculation, who makes the actual payment? How does that happen?
I believe it comes from Treasury. The funds are sent to an intermediary bank, and from there they go to the claimant's bank account.
Okay, so the Treasury takes the authorization order from the special panel, and that's what authorizes the Treasury to disperse the money to the bank, correct?
I believe that's right. They receive an instruction to issue payment. I'm not certain about the mechanics of how the money moves between the Treasury and the banks.
But all we need to know here is the special master doesn't make the payment, right?
I believe that it's done by Treasury.
Yeah. Okay.
I think that's.
And just one other clarifying question. Suppose the fund, this is the reverse of the question Judge Millett asked, not the reverse, same question, different numbers. Suppose the fund has after set-asides and administrative expenses, suppose the fund has $110 million in it. Does the special master have to distribute that $10 million?
The special master then has to make a determination in her discretion whether it is worthwhile to make a distribution, considering the
But I thought
costs.
the statute says if funds are available. So my question is, after deducting administrative expenses and other set-asides, there's $10 million. Isn't that the $10 million that's available?
The $100 million threshold is for when the Attorney General has to appoint a special master. It's not for when the special master has to issue distribution. And just as the special master has discretion whether to issue distribution, whether there's $1 of unreserved balance in the fund, the special master also has that discretion at $100 million. It could be.
Suppose there's $200 million in the fund.
Yeah, I understand what Your Honor is getting at, and there very well could be a point at which the special master would abuse her discretion by not issuing a distribution. That's not the claim the plaintiff has alleged here.
I totally understand that. I was just trying to get you to help me understand how this thing works. That's all. But you acknowledge that there could be a point at which there is an abuse of discretion in terms of the distribution of money in the fund, right?
That's right. Whether there's a judicial remedy for that, is a separate question.
Okay.
But at some point, yes.
Mark, I just want to follow up on Judge Tatel's done. I just want to clarify one more thing. Does the special master have to keep $100 million balance there at all times, or if there's $150 million, the special master can distribute? Put aside. Let's assume there's no set aside. There's $150 million after all your reservations and all your administrative costs. So there's $150 million clear.
Yes,
the special master can distribute that full $150 million, doesn't have to keep, there's no obligation to keep a $100 million baseline in the account.
That's correct. So what the special master has to keep is the amount set aside for conditional claimants and administrative expenses. The conditional claimants piece itself is well in excess of $80 million. And then the administrative expenses.
Are there any more conditional claimants coming in at this point, or is that pretty much set?
I know that there were additional conditional claimants in the third round distribution. I'm not sure whether there will be in future rounds of distribution.
And then on your definition, go ahead. Judge Tatel.
You finish up. Go ahead.
I was gonna ask something different. So if you're still
I
on
have
the
something
same
different too.
Oh, okay. Well, I wanted to follow up on your position that authorized payment means that determination of eligibility. And, it's a little hard to wrestle with a statutory text because there's a whole separate provision for determining eligibility. And eligibility to receive a payment is not the same thing as authority to make a payment. So it seems a very atextual definition. And it seems like your very eligibility letter itself, the one you sent to Mr. Braun, says, you're eligible and you will be notified about the exact amount of your payment after the special master authorizes the next distribution. So the special master herself or himself has been using this phrase authorized distinct from determining eligibility. So I don't know, there may be, is it really your position that you authorized payment to Mr. Braun back in 2017 when he was first, within the meaning of the statute, determined to be eligible? Or is it your position that when there was that follow-up letter shortly, a month or so before payment, that says, we've determined there can be a payment, here's your pro rata share, go on the website and put in your bank account information? Which of those two do you think is the special or some third step, special master authorizing payment?
Payment to Mr. Braun was authorized when the special master determined that his claim was eligible for payment. And that's that understanding of authorized payment, which, to be clear, is different from authorizing a distribution. But that's the only, construction of authorized payment is the only way to harmonize the disparate provisions of the statute. So take the third round distribution. Congress said that the application deadline for the third round distribution was 90 days after the effective date of the Clarification Act. And then the special master should authorize payment 90 days after that. So there's 90 days between the application deadline and authorizing payment. At the same time, other parts of the statute provide that after the special master makes an initial eligibility determination, the claimant has 30 days, if their claim is denied, to seek a hearing. And after
I understand,
hearing,
but wait, if I can back you up there, as Judge Tatel pointed out early on, that provision about a report to Congress envisions that payments can be made while certain claims are still getting sorted out, right? Because it says, tell us which payments have been made and which ones have not yet been made. And it seems to me very strange to say authorized payment is the same thing as determine eligibility, as opposed to, what do you call that letter when they say, here, you're going to get this payment, here's the dollars you're going to get?
That's a notification of the amount that a claimant is going to receive in a given round of distribution.
And then after that, what does this follow up on Judge Tatel's question? After that, the special master must sign something, do something to inform Treasury that it's time to make payments and here's the amounts, right?
That's right.
Right. Why isn't that the most natural, whatever that is, whatever paperwork that involves, why isn't that the most natural reading of authorized payment?
So again, that doesn't harmonize the disparate provisions of statute, because there's no way that the special master could have reached that point within 90 days, after the application deadline.
That happened for a third distribution. At some point, I put aside the deadlines. At some point, the special master had sorted enough things out that she then said, I think it was she at that point, she then said, in whatever form she did, to someone at Treasury, here's who's to get paid and here's how much they are to get. Correct? That happened. That event happened. And that is not the most natural meaning of authorizing payment, when she authorized payment from the Treasury to the individuals?
No, Your Honor. I think that there are a number of ways that a person could interpret authorized payment. The one, again, that harmonizes the various deadlines in the Act, the only one that would have been possible within the 90-day deadline to authorize payment is to make that initial eligibility determination.
Then you have said,
I'm sorry, but I'm sorry to interrupt, but I thought I was following you until you said what you just said. The plaintiff received his eligibility letter years ago, right?
That's right. So
the only thing that has to happen for him to get future payments is two steps. Number one, the special master authorizes payments from a fund. And then after all the hearings are over and the pro rata calculation done, he gets payment, right?
That's right.
Do I understand that? So there's only, so authorized doesn't mean eligibility. The authorization is made to people who have previously been determined to be eligible, correct?
I'm sorry, could you, I'm not sure I understood that.
The authorization that occurs on January 1 for a group of claimants, those are authorizations for claimants who have previously been determined to be eligible, correct?
No, those are, so any claimants, receives authorization.
Take the plaintiff, not a new claimant. I don't mean a new one. I mean, take plaintiff, for example. He was determined, the plaintiff in this case, he was determined to be eligible years ago, correct? Along with a lot of other claimants, right? Thousands of others.
That's right.
Now, with respect to that group of people, what happens on January 1 is if there's money, they get first an authorization, correct?
So their payment was already authorized. Payment to their claim was already authorized years ago. January 1st sets the deadline for when the special master has to authorize payment for any remaining individuals who are going to participate in
But wait, payment can't be authorized. The special master cannot authorize payment as a matter of law just by finding people eligible. Special master also has to find there's enough funds, putting aside reserve funds. There's enough funds to do this. And if your position has been made that discretionary judgment, that has to happen too. Eligibility does not authorize payment. There has to be a determination that a payment will be made. And then there has to be a determination that there's what the amounts are going to be, because it has to be done pro rata. All of that has to be done before payment is authorized. Just being eligible does not, you could be eligible and just imagine there was just never enough money in the fund. That's no payment, no one's payment's authorized.
Mr. Koppel, let me weigh in here. And that is, I don't see why there's a difficulty in differentiating between authorization and expenditure. And in fact, the sunset provision actually says, divides them, effective on the day after all amounts authorized to be paid are expended. So there is the action of authorization, and then there is the action of cutting the check, of expending the funds. I don't see why you're not making that argument.
We absolutely agree with that position, Judge Henderson. That's absolutely right. Authorizing payment does not mean issuing payment. The best way to understand the term authorized payment, the way that the VSST fund has and the special master have understood in the past and have reported to Congress this understanding, is that they authorize payment on a claim when the special master makes a determination of the eligibility of that claim. Payment isn't actually issued until the special master determines that there are funds available, there's money available in the VSST fund, authorizes the distribution, and performs the pro rata calculation. The special master authorizes payment on a claim when she determines that the claim is eligible for payment. That is again how the special master has applied has interpreted and has effectuated the statute in the past. Congress understanding that, and they understand this because they received the reports from the special master that lay that out. They use that same term, authorized payment, in the Clarification Act, thereby adopting it or ratifying this under the VSST fund's construction of the statute.
All right.
So can we go back to just the language of the statute here? So it says, January 1st is the second calendar year that begins after the date of initial payments. That's where we are now, right? Okay, funds are available in the fund. The special master shall authorize additional payments on a pro rata basis. So on January 1 of this year, the special master authorized additional payments on a pro rata basis, right?
In this particular year, the special master determined there weren't sufficient.
No, I'm sorry. I'm good correction. Let's assume there was money. Okay.
Yeah.
So on January 1, the special master would authorize additional payments on a pro rata basis. So what would the letter say? It would say, what? You'll get another payment this year?
So the special master announces that there will be a distribution this year, and by January 1st has to issue a decision on the application of any claimant who has submitted his or her claim by the deadline set by either statute or the special master.
And what will that letter say on the January 1? Will it say you will get a pro-rata? Is that what it will say?
It will say that your claim has been deemed eligible or your claim has not been deemed eligible. You have 30 days to seek a hearing.
Okay, and the pro-rata calculation is made later, right?
That's right. So then
you know how much there is. Okay.
That's right. So then the claimant has 30 days to seek a hearing. After the hearing, the special master has 90 days to issue a final written decision. Only once all claims have been finally decided can that pro rata calculation be performed, and then payments can issue.
Okay. Let me ask you one other question that relates to the blizzard of 28J letters we got today. And,
Yes.
and that has to do with whether or not the Attorney General has in fact appointed a master. You say the master was extended, right? There is a master now, correct?
That's correct. The special master's term has been extended for an additional year.
What is your view of what we should do with this 28J letter from the plaintiff about this? His argument in the district court was this claim was moot because the district court said this is a claim that was the district court considered to be moot, correct?
That's right. And plaintiff has forfeited and waived any challenge to the dismissal of this claim seeking the appointment of a special master. He didn't argue an exception to mootness in the district court. In the Court of Appeals here, he actually said he confirmed, he admitted that the claim was moot. So if a new injury has occurred, plaintiff has to file a new complaint.
Okay.
Has waived that.
That's all.
Can I ask one
That was my
follow
last
up on that? Yeah, one follow up on that. Was the special master's term extended by the Attorney General?
My understanding is that it was not done by the Attorney General over the weekend. Since plaintiff first raised this issue, I haven't been able to determine definitively which official it was that extended the special master's
The Justice Department hadn't figured it out beforehand? The special master's term had expired?
A Justice Department official had extended the special master's term back in December. I believe it was the Assistant Attorney General for the Criminal Division that authorized that, but I haven't been able to obtain a definitive answer on who that was over the weekend.
Has there been an internal delegation from the Attorney General to allow you said the Associate Attorney General for the Criminal Division?
Assistant
Attorney General to make this decision?
I'm
not sure. I haven't been able to.
Your point I take it is your bottom line is, look, if there's anything here, it's up to the district court, right?
Well, it's up to the district court on a new complaint, right?
Yeah.
The claim was dismissed.
Yeah, I didn't say that. You said your point is it's just not before us right now, right?
That's right.
All right, great.
That's right.
Thank you.
All right, thank you, Mr. Koppel.
Oh wait, I'm sorry, Judge Henderson.
Yes.
Can I ask him one more question?
Sure.
Would you please explain the government's view of this section HI that was the subject of the other 28J letter? What is the government's view about what this is? Within 30 days after authorizing the payment, shall submit a report to Congress on the payment of eligible claims, which suggests that payments have been being made since January 1. And then when I asked counsel about the phrase, the amount of outstanding eligible claims, he said that didn't have anything to do with this. What do you think this provision means?
So subsection I requires a special master to report to Congress on the status of claims on a variety of data as of a given moment in time, 30 days after the deadline to authorize payments. That doesn't suggest that all payments will have necessarily have issued by that date, but that's when the special master has to issue the report to Congress. And the numbers will, of course, be updated in the next report whenever that occurs. So the way that VSST fund has operationalized this in the past is with the first round of distributions 30 days after the deadline to authorize payment, the special master sent a report to Congress. Payments had not yet issued, and so after they did issue, the special master sent a supplemental report to Congress with updated numbers.
Okay, thanks. I get it. Thank you.
All
Sorry.
right, Mr. Tolchin, why don't you take 2 minutes?
Yeah, I'll try to stay within that. Very quickly, when I filed this case in the district court, there was no special master. They appointed a special master while the case was pending. That's what made the issue moot. If I'm correct that the special master's term expired while the appeal is pending, that puts us back to where we were when I filed this complaint. And I can understand if the court, the court could address it de novo, the court could remand that issue, but I don't believe a new complaint is necessary. But it should call into question in the court's mind, I believe, what Mr. Capel is telling us about the position of the special master, if in fact there is no special master. That's all I want to say on that point. I want to briefly talk about the effective date issue. Judge Tatel, the section and the amendments made by this section shall take effect on the date of the amendment of this act means that the change from 50 to 75% happens on the effective date of this act. Of course, we don't go back in time to people who got distributions in 2015 and give them money that they weren't entitled to by the allocation at that time.
Why not? Why isn't that what the plain language requires?
Because what the plain language requires is that distributions be made by January 1st of each year. So those ships have already set sail. But by making the amendment that we've changed 50 to 75%.
That would seem to cut against your point that we need to go back and make the 50% be 75% since 2015. The ship has already sailed, payments have already been made. And so as the Clarification Act said, we're just going to start with a new rule in 2019 going forward.
Judge Millett, the problem with that is the thing that becomes effective on the effective date of the Clarification Act is a statute that says 75% of the funds forfeited or paid to the United States.
No, we have to read whole statutes. We don't read statutes in little pieces. We have to read the whole statute. So under your theory, we would have to go back and start at least with section 2 and say, beginning on December 18, 2015, this is what should happen. If you read the statute as you want us to, we begin on December 18, 2015, and then we get to Romanet 2 and say, beginning on December 18, 2015, 75% shall go. You can't just look at it in isolation.
I agree that you have to read the whole statute, but when you have a Clarification Act that's changing one provision, you have to look at the thing that's being changed. And it did not say change 50 to 75% from the effective date of the Clarification Act. It was left saying 50 to 75% of the funds deposited after December 18, 2015. That's the law as it's written. If somebody beamed down from Mars and read the statute, that's what he would see from it. He does without bringing in any other outside information. The statute itself says now 75% from 2015, not from the effective date of the Clarification Act. And I am a minute and a half over on my 2 minutes, so I don't want
All right. Mr. Goldman, why don't you take 2 minutes? Unmute yourself.
Thank you. Thank you, Your Honor. Thank you for the extra time. Again, I agree with what Mr. Tolchin just said. If you look at the statute, it talks about helping those who were in the fund before with a payment taking place in 2019 or 2020. Doesn't talk about recomputing the numbers as to what people received earlier. Doesn't talk about disgorging attorney fees earlier or any of those other consequences. What it talks about is gathering a sum of money so that people could have a meaningful compensation. In the past, people got 4.2%. This year, 9/11 victims got 0.76%, 0.75%. That's because there wasn't money moved as the statute said it should have. Congress.
So Mr. Koppel said that there isn't that fund of escrow money that you had thought you had referenced, or if there is, it's so minuscule, it's not going to serve the function that you wanted to here. And so, to be clear, then your theory, since that money is not there, let's assume the government's accurate about that, and it's not there.
Okay.
Then there's no third fund. Then the only place to get this differential is the general fund. Is that correct?
I think the question the court is addressing is remedy. And I think based on Mr. Koppel's unknowns, the words likely spent, the words how much is in there, then the question is remand. And then that's the determination of the remedy would be within the district court.
I'm just asking you. If I don't understand that answer other than we don't get to say to district courts, go back. We don't get to say go back and you figure out what to do next. We say if we'd have to say whether they could take money out of the general fund or not. That's a pure legal question that this case seems to pose for us.
I do not believe they can take funds out of the general fund. I believe that funds could be taken out of the funds that are being put aside, coming from sanctions money, fines, and the like.
So if they can't get the money from the general fund, then they just can't do what the statute plainly says to do under your view.
I do not believe they can take it from the general fund, but I believe there could be a judgment entered and it comes out of the funds from forfeitures and the like, which is the funds that are to be split up.
Okay, thank you.
All right. Thank you, gentlemen. Madam Clerk, if you'd call the next case.
Case number 19-1236 et al. Kentucky Municipal Energy Agency et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Noorani for the municipal petitioners, Mr. Clement for the Louisville Gas and Electric Company and Kentucky Utilities Company petitioners, Mr. Ediger for the respondents.
All right, Mr. Noorani, good morning.
Good morning. May it please the court. Latif Noorani for the municipal petitioners. I've requested 2 minutes of time for rebuttal. As a result of FERC's orders on review, rates to the city of Frankfort, Kentucky have gone up by millions of dollars. The people of Berea, Kentucky have limited competitive options to choose from when replacing their soon expiring power supply arrangement. These harms to rates and to competition are precisely the harms that FERC was required to consider when making a public interest determination pursuant to Rate Schedule 402. If FERC refused to consider the rate impacts, and it lacked sufficient evidence to assess the competitive impacts. Let's look at the competitive impacts first. Usually, FERC evaluates competitive harm following the DOJ guidelines by testing for market concentration. And here we know the market is already highly concentrated and repancaking rates will increase concentration beyond FERC's own thresholds. As the dissenting commissioner pointed out, the market concentration test suggests that the municipals will have limited access to competitive supply during critical periods. But FERC adopted a new test here. Will there be a sufficient number of competitive suppliers after rates are repancaked? Now, FERC said it considered 3 factors taken together to make this sufficient number finding. And under this court's precedent, if it finds any one of those factors deficient, it must remand. So what are the factors? First, there was a few dozen suppliers that responded to energy agency solicitation when rates were still depancaked. As the dissenting commissioner pointed out, that just shows that depancaking achieved its purpose of promoting competition. The question that FERC asked is how many of these suppliers would have been competitive without depancaking? And on that, the record is silent. FERC's second factor.
Sorry, can I just clarify? I thought it wasn't silent because in fact you had a number of power sources outside MISO that are obviously not affected by the deep pancaking rule.
Right. So the FERC noted this 65% of energy agencies' power is coming from resources inside MISO. There's exactly 3 resources. Right? It's not a large number. It's 3 resources. One is owned by Paducah. One is owned by the city of Paris. The other is a old unit, the JAPA unit, which is great. It was a fire sale deal because it was already set to expire this year. So when they purchased the output from that plant, they knew this was like a short-term gig that they could get, and that plant was going to go out of service very soon. So they took that fire sale deal, but that plant's going out of service imminently. So really, there was only 3 suppliers, 2 of which were their own, and 1 was this mothballed plant. So that's all the evidence there is. Like there's 3 suppliers, and more importantly, even though 65% of energy agencies' power was coming from inside resources, Princeton and Paducah have 100% of their resources coming from outside from MISO. Owensboro has 100% of its resources coming from MISO, and Berea and Benham, who are former requirements customer, also have 100% of their power coming from MISO. So 3 is not sufficient.
Did you argue that all of those details to FERC in your original argument and at rehearing? I
believe so. I mean, I think, yeah, I can find the citations for you. But on rehearing, we pointed out why the 65% number wasn't relevant.
Well, I mean, I meant the one about the fire sale one that's going out of operation.
Yeah, I think I recall a footnote. I'll find it for you on rebuttal. But I recall a footnote in our rehearing brief that listed out with citations to the record where those plans are.
Can I take you back to what you said at the beginning with respect to Section 203 in the Commission's public interest regulations? Commission interprets them to require them to consider only the public interest factor underlying the mitigation measure. In this case, horizontal competition. So that's the Commission's interpretation of the statute to which we owe it deference, and its own regulation to which we owe it even more deference. So what's your best argument for us disagreeing with the Commission about that?
So I think the plain text of the statute, the plain text of the regulation that articulates these factors disagrees with FERC's interpretation. But more importantly, FERC's own precedent disagrees with it.
Explain that, would you please?
Sure. So if you look at the text of the regulation, this is 2.26.
It says the Commission will generally consider the following factors, right?
In addition to others.
But it says generally. Right. It doesn't say it has to. It says it will generally consider these. If I say I will generally consider 3 things, it means I'll generally consider them, but I might not. And the Commission has said, in circumstances like this, we're only going to consider the condition that led to the mitigating factor in the first place.
The Commission sorry.
I just don't, we give heavy deference to the Commission in terms of interpreting its own regulations. So I haven't seen in your brief or heard from you yet what basis we have for second guessing that.
So I would say first that this is in the contract, the parties expected. At the time they entered into the agreement, the parties expected that FERC would follow what it always had followed, that it considers the relevant factors in the public interest. Now, this is the first time FERC has ever had a factor before it and not considered it. Right? So all the cases FERC cites for its history of only considering the original mitigation factor were cases that didn't have protests or cases where the protests were addressing different issues. And in all of those cases, FERC addressed the issues that were raised before it, right? So I think FERC's refusal to address an issue that was raised before it is the real problem.
Or it's that it's a general they've said we'll generally consider it and it was raised. We don't have to decide one or the other. It's you have those two combinations together. Should they have either addressed it or explained why not? Is that your position? You're saying that you argued it and that's the real problem. But you were saying before it was the regulation says we'll do it. I'm just asking why it's not the two of those things together. You don't have to take those apart. Okay.
Yeah, I don't think you have to take them apart. I think it is both.
Can I ask about your non-MISO purchase power agreements and that you wanted to have pancaking for sort of the backup or economy energy from within MISO? How is that workable? How will they even know if you're obtaining energy from within MISO that it is backup or economy energy as opposed to simply extra contracts within MISO? I don't even understand how that's administrable, your proposed position.
Right. That is, it could be difficult to administer absent the fact that we've already reserved 100 megawatts of transmission. So the Energy Agency reserved that transmission.
I'm talking about the backup power purchase agreements.
That's right.
Apart from the transmission reservations are different than purchase power agreements, correct?
Correct. And so,
can I just ask, are the backups, are they subject to existing contracts? You have those contracts, right?
So there are some contracts now. Some of it is market energy that is bought in the spot market. Some of it is pursuant to option agreements. But the backup and economy energy agreements were not entered into before March 2019. So those backup agreements are not part of the transition mechanism. The question Judge Millett asked is, how would you know if a particular transaction, a particular power purchase is for backup or economy energy? And I would say, if it comes over this reservation that was made for that purpose, any power that comes over that transmission reservation, we can presume is for backup and economy energy, because that's why we purchased the reservation.
So the reservation isn't going to be used for other power?
So it's right now it's used.
The transmission reservation now is only used for that? That doesn't seem like, that seems an odd, you have all this transmission, you have a lot of transmission, the power in reserve, transmission reservations there, and you're telling me the only things they would ever be used for is for backup or economy energy?
Yes, I am saying that, because there's another 100 megawatt reservation that is tied directly to the contract from Big Rivers. And similarly for Princeton and Paducah, they reserve these transmission, when they make a power purchase agreement, they reserve specific transmission for it. And when they have economy energy, which is most of it, on this particular 100 megawatt transmission, that's the reason it was entered into, was for economy and backup purchases. And it's not that much.
It still doesn't tell, I mean, it's still, how do they know? I mean, I get that contract for economy energy, for example, is going to go over that transmission reservation, but that still doesn't, you're going to use that transmission authority or ability to get that energy to you, but that still doesn't police whether in fact that really was an economy energy that was a backup for your alternative energy, as opposed to, hey, we just want to get this energy into our system. That is, it's that so policing. I'm still not getting how it gets policed, right?
Right. So the policing part of it is, so, you know, if I were establishing the standard, I would say that it is presumed that anything coming over this particular pipe, there's other pipes too, new ones that are not part of the transition mechanism, but anything coming over this particular pipe is presumed to be for backup and economy energy for these resources.
How does someone rebut that presumption? How would Louisville rebut that presumption?
So when
I'm sorry, I'm losing Louisville as a shorthand for that really long acronym.
Yeah, Louisville Gas. Yeah, Louisville Gas is fine. When Louisville Gas, there's what are known as E-tags, right, which record the sink and the source, the origin and the destination of every power purchase. So every time power is brought over,
I get that it's coming to you. That's all that seems.
But this is
my ignorance of the process. Sure. I'm sorry. I know this is my ignorance of the process, but okay, yeah, you're getting it. You're getting over your transmission reservation. You're using your backup or economy energy contract for it, but it may be that your outside MISO source is doing just great. You just wanted some extra energy because there's a heat wave, or for some other reason. I don't know how they can police that it's really being used as you just needed more energy as opposed to it's your economy energy.
Right. And so the tag that comes along with the import, it says what the source of the power is. So I think Louisville Gas could use that tag to police and rebut the presumption that power brought over this pipe is not for economy energy, or as Your Honor mentioned, they could look at the load. They could see that you're bringing power in, your diesel units are running, and your Paducah unit is running, and the sun is shining, and you're still importing power. They might be able to rebut the presumption. So there's lots of ways they could rebut that presumption, I would say, if they were trying to police it. But there's also no reason to think that the Energy Agency would abuse this.
And then your the hydropower agreement that you have, there's some parts of the record describe it as ownership. Others treat it as just a power purchase agreement. Is there an ownership interest in there? Investment or ownership interest of some sort? For 50 years is an awfully long time.
Yeah, it's the hydro contracts my understanding is it's an ownership interest of a sort. But the plants are actually owned by American Municipal Power, and Princeton and Paducah are participants in the project. And so the exact financing and like legal ownership, I'm not sure how that works exactly. I know that Princeton and Paducah are participants in this project, which is owned by American Municipal Power.
Why was it reasonable for FERC to treat it's effectively I'm just going to use a shorthand, I understand your qualifications, but effectively an ownership interest, and getting power through an ownership interest, which involves so much more money and so much more potential use and control of a process, the same as a plain old arm's length power purchase agreement. Can you tell me why it was reasonable and where in the record they explained why that would be reasonable?
So it's reasonable because an ownership interest is more of a reliance interest than a mere power purchase agreement. So if you're considering reliance interests, right, then the reliance interest in buying something and issuing bonds backed by your citizens is actually a really big interest. So that is, I think, the logic for why that should be the case. And I will say that if you look,
FERC didn't seem to be. Go ahead, finish your point.
In the initial order, in the rehearing order for the 2019 rehearing order, September 2019, FERC clarified that it wasn't that all long-term binding financial commitments do count. So FERC, the test that FERC established both in March 2019 and then in clarification in September was this principle of binding financial commitments that are long-term. And an ownership interest is exactly that. So that's the principle FERC established. Nobody contested that principle. The question is only the application of the principle.
I just have, if you bear with me, I have one last question. Sure. So it's applied to Prairie State, which is your own sort of generating, it's a source for generation of power. It's owned by you. What can the deep pancaking provision there be used not just to provide power to Princeton and Paducah, but if you also wanted to send that money through the same transmission system and then off to other Prairie State customers? The deep pancaking would apply just the same, I take it. There's no, you don't have to, the deep pancaking isn't limited to providing power to Princeton and Paducah. It would apply to the extent you're also using this to send power elsewhere.
Under the transition mechanism, that wouldn't be permitted, right? So the transition mechanism is clear that you're only allowed to use it to deliver power to the cities.
For the city's use?
Yes, for the city's use. And I think the bond provisions because they're municipal bonds. I don't even think they're allowed to sell it to, as far as I know, I don't think under municipal bonds, you have to be using them for public purpose. But there's, Princeton and Paducah use this power, right? They match their load to the imports all the time. So it's not hard to.
Do they use more of Prairie State Power than, I mean, does the investment interest in there allow you to obtain more power from Prairie than Princeton and Paducah need, and it goes elsewhere? Or is that all the interest, all the ownership interest is limited to? Because it seems like it's producing a lot more power than these two little towns could ever use.
Sure, but these two little towns are only a small portion of the ownership of the full unit, right? So, but the only power that's being imported into Kentucky from Prairie State is for Princeton and Paducah. None of the other cities in Kentucky have rights to it, and Princeton and Paducah wouldn't sell. There's no contract for Princeton and Paducah to sell that to any other Kentucky entity.
Thank you.
All right, Mr. Clement, we'll hear from you if you'd unmute yourself.
Good morning, Your Honors, and may it please the court, Paul Clement for LG&E, and I also would endeavor to save 2 minutes for rebuttal. This case has its origins in a 1998 merger where FERC identified competitive concerns in one and only one market, the market for KU requirement customers. Princeton and Paducah were never in that market. They were TVA requirements customers in 1998, and as of early 2005, they informed TVA that they were withdrawing in favor of their investment in Prairie States, and that would thereafter serve their needs. By that point, LG&E had announced already its intent to withdraw from MISO. As part of that process, in 2006, LG&E agreed with both customers in the requirements markets and others potentially affected by LG&E's MISO withdrawal to a FERC-approved schedule, Schedule 402, that depancaked certain transmission charges. Nothing in that schedule promised that it would last in perpetuity or that contracts entered in reliance on it would be grandfathered. To the contrary, the schedule itself made clear that it could be revisited as market conditions changed. And change they did. Indeed, so much has changed in the ensuing 24 years that the concerns that motivated FERC in 1998 that a requirements market limited to a handful of players would lose one of those players are unrecognizable today. Today, FERC estimates that roughly 100 suppliers could compete in that same market. For that reason, FERC sensibly concluded that depancaking is no longer needed to mitigate market power concerns in the only market in which FERC ever identified any such concerns. Thus, it bears emphasis that FERC concluded that no depancaking measures remain necessary for competitive concerns today. None. FERC did not find that such measures would be unnecessary in 5 years, or unnecessary in 10 years, or unnecessary in 35 years. They found they were unnecessary today. And so that leaves only the question of accounting for the reasonable reliance interests of those who have relied on the notion that the depancaking measures would continue in place. Given the massive changes in the market and the express provisions for modifying Schedule 402, any reliance interests are somewhat questionable. But with respect to the just negotiated power purchase agreements with relatively short tails of 2 to 7 years by those participating directly in the market, that was the focus of FERC's concerns, LG&E does not take issue with the modest grandfathering associated with those agreements. But extending the grandfathering to investment decisions made years earlier and lasting decades longer by parties who have never been in the requirements market is a fundamentally different matter. Princeton and Paducah have never participated in the market that was the sole concern for FERC's competitive concerns.
Are you disputing the fact of their reliance that FERC found, or are you accepting that FERC found as a matter of fact they had relied unreasonably in its view, and you're arguing some legal prohibition that it was arbitrary and capricious for FERC to have made the call that it did?
All of the above, Your Honor. I mean, we really had 3 sets of arguments when it came to Princeton and Paducah. One is that there was no reliance in fact. Two, that any reliance would have been unreasonable as a matter of law. And then third, that even if you accept those, that the grandfathering went on too long.
Right. So as to your middle one, I mean, facts are very hard to say there's not substantial evidence for on this record, given the thing. I mean, I don't need to recite to you what FERC already said about that with respect to Paducah and Princeton and Prairie State. But as to
because I do think that if you look carefully at what FERC did, we're not actually suggesting that they sort of got the facts wrong. What they said, we said they didn't rely on fact. And in response, we did that in our rehearing petition. And what FERC said in response was they reasonably relied, based on in 2019, based on the schedule being in place. So we were making a factual argument. They didn't rely on fact. And the response we got was, well, it would have been reasonable. So
no, they went on. They have said in their decision that, look, after depancaking came in, that's when they sort of jumped in with both feet to this investment. Just as a matter of fact, that's when they really jumped in, and so that showed factual reliance.
With respect, Your Honor, I think that's what my friends, the municipal interveners, have argued. I don't actually read FERC as finding that. And in all events, I think as a matter of fact, the facts are pretty clear that even before the depancaking schedule was issued, the folks at Princeton and Paducah had already committed irrevocably $800,000 as their initial investment and millions of dollars in additional ongoing payments.
No, but they gave up after the depancaking. They gave up an ability to sort of get out of the contract, right?
They finalized it. They finalized after that.
They gave up a right to get out of it, right?
They did, Your Honor, but here's what's missing. Here's what's missing. There's no internal document at Princeton and Paducah that says, in making this investment decision, we are relying on the fact that these depancaking will be in place and will last forever. And that's what's so unrealistic. And Your Honor's own questions sort of drew this distinction between the investment decisions and the ordinary power purchase agreements. And I think part of the reason that those should be treated differently gets back to the questions of reliance in fact and reasonable reliance. Because with respect to the power purchase agreements, these are recently entered agreements, and they're going to be in place for 2 to 7 years longer. The last one of those expires in 2029. So in the context of that agreement, to say you're going to rely on the current regulatory environment, that seems reasonable. But when you're making an investment decision that's going to have a tail that lasts to 2057 in the case of the hydro plants, or potentially even longer with respect to Prairie States, the idea that you reasonably relied on the current regulatory climate remaining in place, and that if FERC ever changed it, they would grandfather you, that's not a reasonable reliance. I mean, there's no reason the Schedule 4.
You seem to accept that it's a reasonable reliance for a certain period of time, because you're not contesting grandfathering for, what is it, I think it up to 10 years for some of them on yours, or is it 10 or 20? I forget what the other ones are, but the power purchase agreements, you're not contesting that as being reasonable.
We're not contesting that, but there's two differences there. The longest tail is 7 years.
Right.
So 2029. And
no, I know, but you seem to be making a general argument that you can't reasonably rely on this regulatory scheme staying in place. And of course they can. Your argument is a time that it's not reasonable after a certain amount of time.
Well, I guess what I'm saying is, I think there is another difference between Princeton and Paducah and the other municipals for which they entered the power purchase agreements that we don't contest. And that is, the other purchases were people who were always in the requirements market. And for those people, they may have had a different sort of reliance interest, because it's relatively unusual for a merger mitigation agreement to be changed. It's possible, but that's more than an ordinary sort of rate. With respect to Princeton and Paducah, they were included in Schedule 402, not because they were in the requirements market, but simply because they might have had a regulatory ability to protest the decision of LG&E to withdraw from the MISO in 2006. And that's different in character, because there are plenty of FERC cases, including the Columbia Gas case and the Northern Pipeline case that we cite in our papers, where when you're talking about normal rates subject to revision under 205, that there are no reliance interests whatsoever. So, and that's different from the entities that were in the requirements market, who are really the core people who would be subject to the 203 review. And so we draw at the outset, we have an argument that basically says for Princeton and Paducah, they had no reasonable reliance interests. And then we have our second argument, which is in all events, even if they had some reasonable reliance interests, because those were investment decisions with very long tails, the idea that they would have a reasonable reliance interest in the entirety of the tail is categorically different from the people who were in the requirements market and had much shorter tails. And so you create this situation where you have something of like a double irony here. The people who were furthest removed from the core concerns of the merger mitigation condition are the ones that are benefiting for the longest period of grandfather. And I mean, just to put this in clear terms, like, you know, I will have my 91st birthday and Princeton and Paducah will still be enjoying grandfathering under the hydro plants. That's what it means to extend it all the way to 2057. So the idea that you're taking a rational condition on a 1998 merger, and in 2019, FERC has determined that it no longer is necessary for market conditions at all today, no longer, and then you're going to extend it to 2057. That is not a rational balancing of kind of reliance concerns on the one hand and getting us back to a regulatory regime that makes sense on the other. That skews the balance entirely in favor of reliance interests. And of course, FERC itself recognized that in the context of prairie states.
Didn't Schedule 402, and I'm sorry, I can't find the spot right now, but didn't Schedule 402, which was approved by FERC, talk about, maybe it was the approval order, one of them talked about not just the pre-existing requirements, but also protecting future, use the word future requirements customers?
I don't know about that particular language where it is, Your Honor, but I mean, you got to look at, you know, obviously the schedule as a whole. And one of the things that the schedule specifically does is it provides a mechanism for it being revised. And I suppose the parties could have built right in there the idea that, and when we revise it, all existing contracts will be grandfathered, but it doesn't say that either. So the idea that you're going to rely reasonably for 50 years in making an investment decision.
You know, about 50 years, I know, but for some time period, right? We have to look at that, right? When you're for Princeton and Paducah, you're saying no reliance at all, zero time period. Isn't that your position?
I am. And the reason I'm saying that is because with respect to them, they're not in the market that FERC is concerned about. So they are in Schedule 402. I don't want to be misunderstood. They're in there, but they got in there for a different reason. They got in there because they had potential regulatory objections, not competitive objections, to LGE withdrawing from the MISO in 2006. I mean, one way you can just sort of feel the difference is in 1998, Princeton and Paducah did not object to the merger. They had no business objecting to it because they weren't in the requirements market. In 2006, they have a regulatory objection to Princeton and LG&E withdrawing from the MISO. And that is part of what's resolved in Schedule 402. But with respect to them, it's not any different from...
It's done against a statement that is sort of essentially recognizing that FERC wants depancaking now. Might change in the future at some point. But that, right, you knew this was what you're going to have to do to get out of MISO.
Sure.
So that's been for some time period. I'm not saying not, but for some time period.
And it's already been way over a decade, which is the normal length of a lot of other merger mitigation conditions. And we're not asking to retroactively get our payments back.
No. But all right. So they were in, and covering them was something that your clients thought they were going to have to do to get FERC. So for the first request got rejected, you're going to have to do this to get approved to get this withdrawal from MISO. So many layers to this case. Approved was have this rate 402, have this rate schedule, the schedule there. And it was going to have to include these folks. Right, Perry,
Sure.
and Princeton and Paducah. All right. And then so now the question is when Congress, I don't know where my language is today. When the commission said, all right, now we're going to undo that, even the depancaking that we had in Schedule 402, protecting the reliance interests of folks in Schedule 402 is what FERC seemed to require. I think that seems to be the easiest thing. The MISO to 402 and 402 to depancaking was protecting the interests of even those entities that were in Schedule 402 that might not have been original merger. Protect the original merger requirements, folks that were being, not merger requirements, the original requirements customers that were being protected from the original merger. It went beyond that by Schedule 402, and then the depancaking is protecting the same folks and the same interests that were protected by Schedule 402. And so that leap from they weren't there at the time of the merger, they're not an original requirements customer, that's all FERC can look at, seems to ignore this evolution, which in the course of it recognized a protection both for existing and future requirements customers.
But let me try one more time, Your Honor, because what I'm saying is, yes, they were in 402. But if the way to think about this, I think, is that with respect to the original requirements customers, they were in 402 because of concerns that trace back to the 1998 merger. On the other hand, Princeton and Paducah are in 402 because of concerns that are really limited to regulatory concerns about LG&E's withdrawal from MISO. Mm-hmm. And the reason that distinction is important is because there's plenty of FERC precedent that says when it's an ordinary contractual tariff, you may have made, as a party who's benefiting from that tariff, you may have made investment decisions, you've made purchase agreements, you may have made decisions based on that tariff being in place. And generally speaking, FERC doesn't care.
Right, but Schedule 402 was not an ordinary contract, right? You can say it's not the same as the original contracts requirement, original requirements customers, and maybe they're somewhere in between, but they're not. It was not the same as a plain old contract. And in fact, there's the line in there about we think we got to do this because otherwise FERC isn't going to sign off because it's in a heavy depancaking mode right now. Obviously, that's a paraphrase, but that language is in there, and so we have to wrestle with that.
So, with respect, Your Honor, I think that with respect to the Princeton and Paducah and the other transmission customers who are never in the requirements market, it is an ordinary contract. It's a contract that was entered in part because they had the ability to raise regulatory objections to our withdrawal. We had answers. Nobody knew how if we would win or they would win in a regulatory fight over that. So we agreed between ourselves that we're gonna have a settlement here, and we're gonna have this contract that we're going to enter with FERC, and FERC is going to approve. Actually, the original version of it was just with these entities outside the requirements contract, didn't say anything about 203. It was, and that was added only when these two things got sort of mushed together. I mean, one way of thinking about this, Your Honor, is Schedule 402 really has sort of two groups in it. And with respect to the groups that are in it because of competitive concerns that date back to the 1998 merger, it's a pretty unusual animal, and therefore we're more willing to accept a modest degree of grandfathering associated with these power purchase agreements with relatively short tails.
Well, that's one way. That's one way of looking at it. But another way is that, yes, they talked at the original merger, time of the merger agreement, they said we are very concerned about existing requirements customers. But when FERC is worried about competition, it's not exclusively existing competition. There's also forward-looking concerns about competition. It's just not in that moment, it's also forward-looking. And what Schedule 402 did, and when FERC signed off on it, and it's, I think, JA, 267 is where they use that word future. They include within the people that are going to be subject to deep pancaking their future requirements customers. And so they made more explicit there what would have been, I think, had to have been part of their concern with the original merger agreement is not just protecting these list of existing requirements customers, but competition itself and its forward-looking aspects. So future requirements customers too, and that's what carried forward in Schedule 402. So that's just why, to me, it feels like Schedule 402 doesn't fall within your ordinary contract. Like, there's a separate argument you have about how long. I get that, but I'm just trying to look narrowly at this. Do we treat them? How are they to be considered?
But here's the thing, Your Honor. I mean, I may not be persuading you, but I want to take one last try at it with this, which is Princeton and Paducah were never in that requirements market. They are transmission customers of ours. That's a different market.
Mm-hmm.
FERC looked at that market back in 1998, looked at all the different markets. It didn't have any concerns with that market back there. Its concern was the requirements market. And Princeton and Paducah have never been in that market. They were TVA customers at the time, so they were wholly removed from it. And then they made a decision in early 2005 to basically supply themselves with prairie states. So their benefit from Schedule 402 really is essentially collateral. It's, this would be an easier case for me, I suppose, if what my clients did back in the day was have Schedule 402 that was just for the requirements customer and Schedule 403 or 402 prime that was for these individuals. But there is a difference. They were in there for a different reason. And I think that informs their reliance interest. But if I can move to the second piece just very briefly, I'm over my time, obviously. But I do think you're right. I do have an argument about the length of the reliance. And I think even if somebody who is in the core requirements market was saying that they're entitled to a grandfather that extends to 2057 because it was an investment decision, I would be saying that's unreasonable. I mean, there aren't any of those. The people who are in
if it weren't an investment decision, if it were just for some reason a plain contract that went for 50 something years, would your position be different?
My bottom line position would be the same. My argument, I think, would be this much weaker. But I just think.
So tell me how investment when they say, look, whatever it is, we're only using it as to Princeton and Paducah, we're only using it for power, just like a plain old power purchase agreement. Why should we think about investments differently? Or where did FERC go wrong in treating investments the same as regular arm's length power purchase agreements?
Well, I think ultimately the key is that, and this is why I'd be making roughly the same argument, even if it were a anomalous power purchase agreement with a 35-year tail. But I think investment decisions tend to have long tails. Purchase power agreements tend to have relatively shorter tails. So that's in the nature of them. And if you're an agency trying to figure out how do I manage reliance concerns, and and should I give a grandfather? Should I give a partial grandfather? Should I give no grandfather? To treat, even apart from their investment versus non-investment nature, to treat an agreement with a 50-year tail the same way as an agreement with a 2-year tail is inherently arbitrary and capricious on both of the factors they purport to be considering. They purport to be balancing reliance interests versus kind of getting us to the current market environment where we don't need these. And I think on the first prong, it's just not rational when you're making a 50-year time horizon investment to make the investment on the assumption that the regulatory climate isn't going to change for 50 years. These are people in this industry. Anyone in this industry who's been alive for the last 22 years knows that things can change radically over a decade or two.
Is there anything in the place in the? Oh, go ahead.
No. So you can't just simply say,
is there a place in the record that says what the average length of a power purchase agreement is? Because I couldn't find it.
I don't think that's in the record, Your Honor.
That seems kind of relevant to this argument.
I actually don't think it is, because, I mean, FERC's dealing with the situation it has in front of it. And it has, so even if there's a theoretical possibility for a power purchase agreement to last sort of 20 years or 25 years, if there were one of those here, we might have objected to grandfathering that one and not all the 2 to 7 year ones. But that's not the record we have here. We have a record that has a bunch of short-tailed power purchase agreements and some long or almost infinity-tailed investment decisions. Nobody has suggested that that's atypical of power purchase agreements on the one hand or investment agreements.
I think there is a 20-year contract in the record that was grandfathered. I thought I saw one, a reference to 20. I think that's the highest number I saw other than the hydropower plant.
My understanding of the record, Your Honor, the longest one that is grandfathered, putting aside the Princeton and Paducahs, are to 2029. So that's only 7 more years.
Okay.
So there's a huge difference between that. I mean, there's not a huge difference between that and 10 years, which is kind of the compromise on prairie states. But then there is a huge difference between that and the hydro contract.
Sure.
If I could say one last thing about the 10 years on prairie states.
If you'd wind it up, please.
Sure. I would just say that to apply simply the 10-year standard that's used as an initial merger condition to that investment contract without making an adjustment for the fact that this is not an initial merger mitigation condition and FERC has already agreed that there's no need for these conditions, I think is, as a market condition, is I think arbitrary and capricious. That's all I'll say on that. I appreciate the court's indulgence.
All right, thank you. Mr. Ediger.
Thank you, and may it please the court. Thank you, may it please the court. I'm Scott Ediger for the Federal Energy Regulatory Commission, and thank you for hearing the case today. Judge Millett, I want to go to some of your questions. You mentioned the rate schedule 402, and it's in the record at JA 557, and I think you were alluding to this, and I just want to highlight this fact that there is a provision, Romanet 5, which talks about changes to the mitigation. And if you look at the definitions 2 pages before that, the MMD parties are defined to include the TVA distributor group, which includes Paducah and Princeton. And several lines above that, this contract explains that the mitigation in this contract is intended to shield the requirements customers from any repancaking of rates, but it also extends to the MMD parties, which, as I just said, includes Princeton and Paducah. So reading
and any future
requirements customers. But reading these 3 together, if we then turn to JA 559, which talks about changes, that really reads the mitigation described in this section for Princeton and Paducah is intended to implement the section 203.
Sorry, it's going to take you a second to catch up to your site. 559, was that last one you said?
Right, JA 559.
Yep, sorry. I'll make sure I have the right one in front of me. Okay. And I'm sorry. Can you make your point?
I'm looking at the bottom of that page, Romanet 5.
Right. And it's intended to implement the merger agreement itself.
Right. And that includes Princeton and Paducah explicitly through the definition of MMD party on JA 557.
And so the commission original merger decision, they're at least confirming there, maybe what wasn't made so explicit in 98, that they were looking not just at the existing requirements customers, but also potential future customers.
Right. I'd point your honor to the 2020 rehearing order, paragraph 4, paragraph 35. This is at JA 358. And the commission finds that it was
Sorry, can you give me your site one more time?
Yeah,
I
JA
can't move through
358.
You're very good at moving through these as fast as you.
Sorry,
No, you're better than me, so I'm slow. What page again?
JA 358. And that's,
Wait, did you say the 2020? Did you say the 2020? Okay, I'm on the wrong 2020 order.
The 2020 rehearing order.
Got it. Okay.
And this is where the commission explains that utilities have a fundamental understanding of what the transition mechanism is intended to do. It's not whether they were in the market at the time of the merger, but whether they were in the market at the time of the March 2019 mitigation order and had relied. And I guess the point I'd like to make here, Your Honor, and this is going back to your question, is when the commission conditioned the merger on membership and MISO, it wasn't just MISO for the anyone who would have connected to this system would be able to enjoy whatever benefits flow from membership in MISO. So even if it wasn't exactly stated at that time, those benefits would have been available to anyone. And the utilities argument here seems to be, well, the commission could make a merger condition, but no one can rely on it. And I would just submit that doesn't seem to be much of a mitigation at all.
But I take that point, but I also, to be fair to their point, at least one of their points, they have a lot of points, is we can't rely on it for 5 decades. And that does seem, and I get you say, well, we just looked at the contract and that's the term that it had, but it's because it had that long a term. I'm assuming, you're more expert than me, explain how I'm wrong. I'm assuming it had that really long term because it was an investment contract and not just a pure power purchase agreement. Is that right?
I think that's right. And I think it's also, but I don't think it's entirely fair to say it is such a long term. The commission did impose a limitation here. A 10-year limitation on the Prairie State.
Not that, I'm talking about the hydropower one that's 50, 57. I can't keep all these numbers.
Yeah, it does go.
And I'm assuming that's abnormally long for an arm's length power purchase agreement. And so that must have been, it was so long in part because they were investing. It's an ownership interest, and that tends to run longer.
Well, I think
it can run forever as long as the entity exists sometimes.
What the commission was doing here, priority number 1 was to protect the reliance interests, whether it was done through a contract, a power purchase agreement, or if it was done through some sort of investment, an investment in a coal.
Did FERC articulate somewhere, and I may have just missed it, exactly how they defined reliance interests? Any type of economic reliance interest, or were these reliance interests tied to merger concerns, power purchase, transmission access to their transmission system, or access to their power? Did they define more carefully what the reliance interest is? Because that seems to be some of the issue here.
I think it's the latter. It was the commission said it called it reasonable reliance and rejected the argument that
doesn't tell me the scope of reliance. Right, because I wouldn't have gotten married if I know all these economic things were going to happen, and I wouldn't have the funds now that I thought I would have, because I have to spend it on pancaking fees instead of buying, and taking care of my new family. And surely FERC's not talking about that type of reliance interest. There has to be some boundaries to it.
Well, I suppose that I think we can derive what the commission did. We can derive an answer from what the commission did. The commission looked at the timeline of what had gone on here. And in addition to that, looked at the filings by Princeton and Paducah in this case that stated that they had relied on both starting number 1 with the mitigation contained in the merger order, membership in MISO, and number 2, and is where we started with this, with the rate schedule 402 itself, which utilities submitted to the commission with purpose of complying with the merger order. So in those dates, there's a couple of those dates I want to highlight for your honor is that of course the merger was in 1998, and it's the first agreement that Princeton and Paducah have isn't until 2005, and I just want to emphasize that that was not necessarily a binding contract for their interest in Prairie State. And it's not until after rate schedule 402 became actually on file, accepted by the commission in June of 2007 when they filed a firm contract. And I think the commission was on firm ground in looking at that timeline and saying by June of 2007 that was a reasonable reliance on the contract.
Can I ask you about, I'm sorry, did you want to?
No, thank you.
The consideration of rates.
Yes.
So, the commission actually in the original merger agreement in 98, I forgot the date of the decision. Yeah, the 1998 decision has a whole section of the effect of the merger on rates. Now, there have been protections put in place already, as part of the agreement, but FERC was looking at the effect on rates and concerned about that in particular, as one of the things in particular at the time of the merger. And it seems to me, and we know that effect on rates so it was looked at in 1998 as a concern with this merger, consistent with the regulation. I couldn't find a case where FERC is applying the public interest standard in this merger context, and its regulation applies, and where someone raised material evidence about a significant impact on rates, and FERC refused to consider it. Can you tell me such a case?
Can't. But the commission's stated here, there have been cases where rates have been discussed and those weren't an issue, and the commission clarified that in an order supplemental under subsection B of the statute that you always look back to the reason the measure was there in the first instance, and admit that that's a reasonable interpretation of
so that was a change, because prior to that, including in a prior case involving Louisville, in my shorthand Louisville, for all those Louisville and Kentucky utilities, they had just done it there. They did it in 2018 in Westar, and they did it in Emera, Maine, looking at rates. The regulation said to do it. You had significant evidence here. Now, FERC can have its analysis of it, but there's significant evidence propounded and a real concern about rates. I'm talking about longer term rates here. And FERC said, we're not going to look. Did it acknowledge that it was changing its position and address the reasonableness of that change, other than saying we're just changing what we look at?
Well, the commission explained its position to be sure, and I guess number one, I would push back that this is a change. The commission didn't exactly agree with that, and while rates have been mentioned in some orders, I guess I would argue that was dicta. Those cases did not stand for the proposition that you had to.
Agencies and their analyses have dicta like courts do. And that is, and they were addressing it. They thought it was a factor to, now they can say, we would look at rates, and here no one disputes there's a problem about rates, but that says that rates are something we look at, and here we agree with the parties, it's not an issue. That's still making rates relevant, right? As in the Louisville case.
I'm not sure that's right, Your Honor. The commission didn't, we also don't know of a case that says the converse. No,
but you've got a regulation that says, here's what public interest means in the merger context specifically, in 203 context, right? Here's what public interest means, and we're generally going to consider it. So you've got a regulation that says, this is what we expect we'll be doing. Maybe something will come up sometime and we won't, but this is our general rule. And then you have someone come in with very substantial evidence, and they say, we're not going to do what our regulation says is our general rule. We're not going to do what we've done in other cases, which is address the prong. Maybe it's a quick check the box because it's not in dispute. We're just not even going to, we're cutting that prong out of the analysis. That's what they said here. We're cutting it out. And they're doing that in a case where they said, we're going to look what bothered us with the original merger. And one of the things that they addressed at the time of the original merger was rates. So those three things together leave me very confused as to why they weren't spending more time, why they sort of closed their eyes and said, we refuse to consider rates in this context.
So as you say, Your Honor, the rates were discussed in the merger order, and but there's no suggestion whatsoever that the issue here today has anything to do with that discussion. Those that rate discussion is in the record, and but it has nothing to do with the litigation here.
Mr. Edger, would you, Judge Millett mentioned the Louisville gas case, and I don't think I heard your response to her question about that case.
The commission explained that to the extent that was inconsistent, it explained why the analysis here should harken back to the analytical framework set up by the merger order. And then the commission explained that because the mitigation here only has to do with competitiveness prong, that's should be the sole consideration. The commission ended its discussion. I'm trying to find. This is the rehearing.
You're talking about Louisville gas now. Is that what you're talking about?
It ended its discussion by saying the Louisville case, and this is the 2011 case.
Yes, 2011.
To the extent that was inconsistent, then it clarified here that the right way to approach an order supplemental is to look back at the original order and to consider why the mitigation is there in the first place, and consider it that way. The discussion about rates in the merger order, there's no relationship between that discussion, those matters, and the mitigation at issue.
Well, it's because mitigation things were already in place for rates, right? It wasn't though that they said that doesn't matter. We only care about competition as an end in itself. It's that there were already, redress was already in place that FERC blessed.
That's right, and those.
Right, so it considered it a relevant factor.
Which is its general policy.
At the original time of the merger.
At the time of the merger, but this is a different animal. This is a different case that we're considering here. And
where has FERC before said that competition is an end in itself, all by itself, as opposed to where I look elsewhere when commission to me has said what public interest means. They want competition, but for a reason, to have plentiful supplies of electricity at reasonable prices. They've said time and again, it's the supply at reasonable prices. That's ultimately what the public interest is here. And it sounds to me like what the commission did here was say, we don't care about reasonable prices as long as there is competition as an end in itself. And we aren't going to look at the long term. We're not going to look at the long term. And that seems to me just quite a sharp departure, both from the regulatory text and precedent, and an unusual vision of what their job in the public interest at stake here is.
Again, I think the answer to that is to look back at the framework that was set up by the merger order, and that it set up the reason that the mitigation is here. Reading these orders, there's no way to link the mitigation to other factors like the regulation and rates or any of the other matters under the statute.
And the other thing that kind of whipsawed me about the decision was they say we're only going to look at the original, what it defined then as the original merger concerns as this competition concern. But then it went on and put this whole transition mechanism that has nothing to do with that competition concern. Now, I assume the whole point of the transition mechanism was to serve the public interest, right? They deemed that to be in the public interest?
Correct.
So that seems to contradict the first half of their decision where it says the only public interest we're looking at this stage was the merger, why we had the merger conditions that we had, the very original concern about requirements, customers. That's the only public interest. And then you turn the page and they've got, it's not even listed in their regulation. They've got this, this whole conception of reliance interests as public interests that they're serving. And I understand why reliance interests could be part of the public interest that FERC gets to enforce. I don't think anyone has challenged that here at that level. But it seems to me that FERC has a very sharp break in its conception of the public interest in the middle of its decision. If it really only concerns about competition, there'd be no protection for reliance interests. So it recognizes that it's protecting a bigger public interest, just not rates. How can that make sense?
The commission, of course, does acknowledge that the change in what's happening here with the end of the depancaking, that rates will go up, that they being the customers will have to pay for MISO transmission, whereas they didn't before. But I don't think there's anything unusual in the commission looking at reliance and choosing a proper method to implement its change. There wasn't a time frame that was set before on the mitigation, and I think the commission here reasonably determined as part of its public interest analysis that an abrupt change for customers would not be fair.
I understand. I'm not disputing that at all. What I'm saying is that means that in the first part of the opinion, FERC straitjacketed itself. The only public interest that's relevant at this Section 203 modification stage, not the original merger stage, but the modification of order stage, the only public interest that's relevant is the one that animated FERC's imposition, not self-imposed, but FERC's imposition of merger conditions. That's all we look at. That's what I'm pointing out to you, is that difference. When the next page, they said, actually, there's more public interest we're going to advance here. That's where did they say, we think it's fine to look at a general public interest and explain that transition from we're straitjacketed, there's only one public interest, to actually, we're going to look at a very broad public interest.
I would just say, Your Honor, to that they're two separate questions. The first question is
what public interest they enforce for Section 203 modification requirements would seem to be one question. Define the public interest that you enforce. That's what they seem to be answering in the first one, quite clearly and expressly. It is only the original merger conditions. And to the extent anything was inconsistent, we're clarifying. We are clarifying that this is all we look at. And turn the page and look at something totally different.
Again, Your Honor, I think the way to read these orders is that the mitigation is not needed to serve the original purpose to address the commission's original concerns about mitigation, about competition in the 1998 merger, full stop. And then we get to the secondary question of how do we implement that? And in this case, the commission was confronted with an issue of reliance, that folks had relied on these measures going forward and implemented and therefore, based on that, the commission recently implemented the transition mechanism. I see.
Were you done with that line of questions?
I am done. I'm done.
I just have one question for you, Mr. Ottinger, regarding the transition agreement, the transition mechanism with respect to power agreements that use MISO for backup supply. At page 76 of your brief, you say, quote, municipals do not explain how they could have relied on depacking mitigation when they entered into contract for power not originating in MISO. That's what you say at page 76. But the petitioners give an example of just that in their blue brief, the Ashwood solar facility. They give that as an example of exactly where that happened. What's your response to that?
Well, the Ashwood is not in MISO. It is, and it does not.
It's not, I'm sorry, it's not what?
It is not in MISO, and it does not rely on MISO facilities. And where the commission had to make judgment calls in this case, and one of them was
I thought they said that it does rely on backup supply from MISO. No?
Well, that's the question, Your Honor. And to my knowledge, there isn't a power purchase contract that we could tie to the hydro in, or excuse me, the Ashwood in the utilities region. If there were, that would be something that could be, if it had been in a place on the date of the March 2019 order, it could be covered. But my understanding is there is not an actual power purchase agreement for backup power. And as for—
Do they have a transmission reservation for that?
They might.
To Ashwood?
They
Then why wouldn't that be reasonable reliance as well? It's just, it's another aspect of this contract, of this power purchase arrangement.
But it's not, there is not they could have a contract that the commission would have there could be some more certainty in defining the transition mechanism. But to my knowledge, there isn't a contract. That would be reliance if the municipals had a contract that they could point to that they actually signed, and it might be better evidence of reliance in this case.
I thought for transmission service reservations that there were contracts, and FERC refused to consider those and treat them the same as power purchase agreements, even though they're part of a package that someone sets up. You know, it's too complicated a world just to have a contract with one person to give you your stuff. They purchase these as part of that very arrangement, and yet FERC refused to consider them. Go ahead.
I'm sorry, Your Honor. The commission did include transmission service reservations, but only to the extent of the underlying contract.
Right, but there is a real contract there that was made in reliance on this deep-pancaked system, and it's a mechanism for them getting power, and Congress sort of, what I keep saying, this commission makes their very powerful. And I think cut them off sort of midstream or partway through. You only get half the contract, even though it was a contract, they say, made in reliance under the very conception of reliance FERC applied here.
But they are covered to the extent of that there's an actual power purchase agreement.
I understand that, but the contract isn't covered in full. And why
the
would
reservation isn't?
Sorry?
The reservation isn't covered in full.
Yes.
That is true.
Sorry, just to be crystal clear, there's a power arrangement and there's a reservation, a transmission service reservation, which I should think is its own contract. Is that not right?
I think that's right, yes.
Its own contract with its own term.
Right.
So what I'm trying to get, and I'm sorry if I'm not being clear, and I get you're saying we'll give you 50, 60%, whatever part overlaps with this separate power purchase agreement. But that's what I'm trying to, why does it get treated as sort of a hybrid like that instead of just recognized as a full-fledged contract entered into reliance, and it's part of how they're going to get power on this at this time of this deep-pancaking system?
I think it's a call.
Why is it not reliance for the full? I'm sorry, just to be clear, because I know we're confusing. We've kept you up for a while. Why is that not reliance, the same type of reliance that Congress for the full term of the transmission reservation contract? Why is that not protected reliance?
Because what the commission is trying to do here is to be sensitive to the actual power purchase agreements and arrangements that the customers have done here. And I guess my answer to Your Honor's question is that just doesn't fall into that category. It's not because if the customers really needed that reservation, there would be evidence of that. There would be an underlying agreement. There would be some sort of power purchase agreement underlying it. And here, well,
it's not like they're going to stop getting power. I don't know what I guess I'm confused about FERC's rationale or its definition. I've remained confused throughout this as to how they're defining what reliance counts and what doesn't. They thought these weren't entered in good faith.
I don't want to say that. I would just refer your honor to the make sure I refer your honor to the commission's on this, and they addressed this in the 2019 rejection order, and they said that the transmission service reservations are not by themselves should be protected, and they could be used for future power purchase arrangements, which would just even further perpetuate the mitigation that the commission had determined in the first place.
So the concern was, I've got my contract, say, for 10 years. 5 of it's going to overlap with an existing power purchase agreement that I can point to. And so the concern was whatever the other 5 years of the transmission contract I have are going to be used for some future contract that's not supposed to be protected by this, this sort of final de-pancaking protections, reliance protections, because of the timing, right? Because there wasn't a contract at the time of the FERC's decision.
I think that's right. I think that's right, Your Honor. And the commission's theory here is to return to a market that's no longer being skewed by the de-pancaking arrangement.
Thank you. That's helpful. Thank you.
All right, Mr. Durrani, you can take 2 minutes, and I wish you would, in future, not shake or nod your head. It is distracting and it's also improper.
Sorry, Your Honor. I'd like to address a few things. Just turning first to Mr. Edgar, I'm, to be honest, confused about whether FERC is now saying they made a change to its policy on ignoring rate impacts, or whether this is just consistent with previous policy. Because if it is a change, which it sounds like it is now, then FERC needs to explain that change, and FERC hasn't. So I think if you look at FERC's past practice, that has always considered all the relevant public interest factors. FERC is now saying they're not going to do that anymore. That is a change to past practice, and FERC has to explain it. FERC hasn't. Mr. Clement talked about, he said if his clients had established rate schedule 403, then in this case would be different. They in fact did establish rate schedule 403 and rate schedule 404 for the Illinois and the Indiana municipals, right? They gave de-pancaking to lots of entities. In fact, as the even rate schedule 402 points out, it applies to future requirements customers too. So the fact that the Louisville Gas combined the requirements customers plus Owensboro plus Princeton and Paducah into the same agreement and left Illinois and Indiana to other agreements actually just confirms that Louisville Gas understood they had to provide de-pancaking to everybody, both existing and future customers, to protect against de-pancaking. And finally, we want to clarify 2 things. Your Honor, I said we did, Judge Millett, I said we did comment about the details of the Joppa plant. That's at JA 1026. 1026 is where we explained that to FERC in our
Is that your rehearing or original? That's your rehearing?
That is the rehearing request.
Mm-hmm. Right.
That's footnote 47 on that page.
Okay.
And I just wanted to clarify, when I talked about this, the 100 megawatt reservation, which is in fact a commitment, 38 megawatts of that is reserved for Benham and Berea until their existing power supply contracts end in 24. It's the remaining 62 that is not protected under the transition agreement that is used currently for backup and economy energy. And to respond to Mr. Edgar's point about whether there's evidence that we are using it, a contract was entered after March 2019 for economy energy that uses that pipe. But the important thing is that that second purchase was only possible because we had the transmission reservation already. It's the transmission reservation itself that is proof we were relying on.
You agree that new contract wouldn't be covered, right? Don't you agree that new contract wouldn't be one that would be subject to the prior the Schedule 402 of the prior system because it was post 2019.
That's right. I mean,
so then why should the transmission part of that arrangement be covered?
Because the transmission arrangement was made before March 2019.
I know, but it wasn't paired up with any actual power agreement. So who knows? I mean, their whole rationale is we got to cut it off somewhere, and transmission by itself without power agreement tied to power purchase tied to it is sort of just inchoate ability to get power. I know why they do it. It makes perfect business sense, I'm sure, but it's not what they're protecting. You have to have, I guess they want to say you have to have both halves to be protected. And what's I get there may be some reliance here. What's unreasonable about them drawing the reliance line at that point?
Because it doesn't achieve the goal that they articulated, which is to protect the financial commitments we made in advance.
Right. I guess they never defined reliance very well. So.
And quickly, one last point on the length of power purchase agreements. The Ashwood Solar power purchase agreement is for 20 years. And I did pull up the contract, it's not on the record, but the contract with the hydro units is actually called a power sales contract between American Municipal Power and Princeton Paducah. It is, I think the reason we call it's sort of referred to as an ownership interest is because there was an upfront payment, but it has a fixed term. So if the project lasts beyond 36 years, Princeton Paducah have no rights to it. So it is a power purchase agreement for 36 years, but it's a big upfront payment, and it's called a power sales contract.
All right, Mr. Clement, why don't you take 2 minutes?
Thank you, Your Honor. Just a few points in rebuttal. Just to clarify, it may be that Ashford had a 20-year term, but of course that's not a grandfathered contract because that doesn't get benefit from depancaking ever. So of the power purchase agreements that are at issue here, the longest one does run till 2029. It's obviously just a horse of a completely different color to extend this thing to 2057 as to the hydros. And maybe this was just loose language, but my friend from FERC talked about, he used the phrase protecting reliance is priority number one. With all due respect, that's not even what they said. They said they were balancing the interest in protecting reliance interests with moving on to the current market that no longer needs depancaking. And so I think, maybe it was priority number one in extending this to 2057, but that's not making a reasonable balance of competing interests. That's sort of extending sort of reliance to the utmost. And I don't think they did that in other places. I think this transmission reservation that was discussed is a good example of that. With respect to the transmission capacity reservation that's not associated with particular contracts, FERC reasonably said, that could be used with new contracts. And we want to get out of the depancaking business in this market. And so we're going to reasonably cut it off there. I think they needed to make a similar judgment with respect to these hydro projects. With respect to Prairie States, they specifically said.
Why wasn't it reasonable just to say, we're going to look at the term of the contract that was entered into at the time of depancaking? And the term of the hydropower one was a 57 years, 60 years, something like that. That's the term, and we're not going to pick these things apart and analyze whether there was some quasi-investment angle to it or not. That would be a hard thing for them to dive into as well, wouldn't it?
I don't think so, Your Honor. And I guess what I would say is it's not really balancing reliance interests against moving forward to just identify the outer perimeter of a reliance interest. I mean, to say you entered in the contract and it lasted to 2057, that doesn't actually identify reasonable reliance. It identifies the outer universe of reliance. And I think part of the reason that's not reasonable when it goes that far is because nobody reasonably thinks the regulatory environment's not going to change for 50 years, for 5 years, for 7 years.
I think you said your client, it's not in the record, so I take it your client did not put in information before FERC about what the average length of arm's length power purchase agreements are. So how do I know? I mean, I hear you. To me, it sounds like a long period of time, but how do I know that that's not sort of a reasonable length for a power purchase agreement? And that's what they said they were going to protect. And they get a lot of difference.
Well, I think as evidenced by the way they treated the hydro plants, they actually ended up saying, we're going to protect any agreement, whether it's power purchase or investment, no matter how long it lasts. And we didn't put in evidence as to the average length of either set because
They didn't say any agreement, because we know that with the transmission service reservations, they didn't do any agreement that was entered before the date of the agreement in 2019. They just said, if it's a hard written down, we can read a power purchase agreement. And I don't know that that's not average. I understand your arguments, and it certainly feels like a long time, but I don't have any evidence that tells me that's not average.
Well,
it's not normal.
2 points, Your Honor. I don't mean to quibble, but with respect even to the transmission reservation, they protected the contract for the life of the contract. They just cut it essentially in half. But they did recognize the basic principle that if you entered a contract, we're going to honor it. Our point, which doesn't depend on average lengths, is that there is a radical difference between saying you reasonably relied that the regulatory climate wouldn't change for 50 years versus 5 or 7, and that happens to correspond to the length of investments versus the length of power purchase agreements. It corresponds perfectly on this record. And if there were an unusual power purchase agreement that lasted until 2057, I would still be telling you it's not reasonable to treat that the same as a contract with a 2 or a 7-year tail. The last point, if I just could, is on this idea that I think FERC explained exactly what they were doing here with respect to this merger condition, and what they did is entirely reasonable. If you have a merger mitigation condition that is designed to address one of the 3 factors they considered in 1998, and then you are deciding whether it's necessary or still appropriate, of course you consider the original merger condition that it was designed to address, and you don't reopen the whole kettle of fish. So yes, back in 1998, they were concerned about rates. They put in conditions like LG&E shouldn't raise its transmission rates for 5 years, which would have expired in 2003. You can't use just reopening the one thing that goes to competition to reopen the whole kettle of fish and go back and reimpose rate restrictions or the rest. And it's particularly true here because in order to address a market-related concern, we agreed to something that artificially lowered rates. So removing that, of course, is going to increase rates by that amount. And that's irrelevant to what this was in there for in the first instance. So with all due respect, I think FERC handled this exactly right. Thank you, Your Honors.
All right. Thank you, gentlemen. Madam Clerk, if you would please close court.
This honorable court is now adjourned until Tuesday, February 15th at 9:30 a.m.